Good morning. The most important factor was that the advocate, being a skilled professional, not only in law but also he should be alert while drafting legal notices, perusing the records. Otherwise, there will be a possibility of your case being defeated and you have to cut sorry figure before your client, which may diminish your clients also. So, particularly apart from all other cases, civil suit, whatever, in 138 cases, there are possibility of wrong mentioning of the particulars of checks, date of checks, contrary to the records available, and sometimes even to claim legally sustainable liability, legally enforceable liability. The product which was supplied was also sometimes mentioned wrongly. So that resulted in a case rushing to Supreme Court. If you go through this judgment, this is AAR 2025 Supreme Court 3450. AAR 2025 Supreme Court 3450. This is Bansal Milk Chilling Center. Bansal Milk Chilling Center versus Rana Milk Food Product Limited, wherein they have discussed multi-number of cases, wherever amendment was sought which has not to be granted, and where amendment sought should be granted. Here in this case, this is a case what the appellant before the Supreme Court seems to have filed a complaint under 138 NI Act, Negotiable Instrument Act, on 8/4/2022. And evidence was also given, but unfortunately before cross-examination the counsel noticed the grave mistake committed in the complaint as well as legal notice, wherein instead of stating the supply was milk product, it was stated that this is desi ghee. Desi ghee is also a milk product, but totally the meaning will be different. Therefore, application was filed, and lower court has allowed the application, stating that this will not alter the case of the complainant, and further there was no cross-examination. Possibility of opportunity will be there for eliciting the reasons for not mentioning the correct goods being supplied. Here, the Supreme Court, after discussing sections pertaining to framing of charge, 217, 216 CRPC, and 213 and 240 Bharatiya Nagarik Suraksha Samhiti, wherein charges may be altered, and when the charges being altered, there should be an opportunity for the defense, and if the charges could not be altered, then the original charges should be proceeded with. This was after discussing that the Supreme Court has correctly held that the amendment was only with regard to products supplied. Amendment was moved at stage after summons was issued. Chief examination of complaint had concluded and cross-examination awaited. Considering stage of trial, no prejudice was caused to the respondent. Further, it is important. Amendment did not alter nature and character of complaint. Therefore, the High Court, which set aside the lower court order, was set aside by the Supreme Court and allowed this amendment. So you should be very careful about shabby drafting without perusing the proper record or questioning the complainant on table. This is what actually happens. So be careful, and this with judgment you have to go through multi-number of judgments regarding allowing, not allowing the amendment. Best wishes.